Thank you so much, Madam Moderator. So since we're coming back from closed session and we're about to conduct a regulatory hearing, I'm going to ask actually that Ms. McCochran just call the roll to ensure that we have quorum here.
Okay. Hello. Are you able to hear me?
Yes, ma'am.
All righty. Okay. So Kasuga?
Present.
Cervantes?
Here.
Fu?
Hi.
Arbsheets?
Here.
Nystrom?
Here.
Nystrom? Phillips? Phillips? Rescate? Rescate? Rogers?
Here.
Tate?
Here.
Quorum established.
Thank you. So quorum being observed. Before we take this item on, just a little bit of clarity on where we're going together on our first day. So we're going to take up these items, but I want to say a couple things about our closed session hearing. So upon the conclusion of open session items at the end of the day, inclusive of this hearing, the board will go into closed session for the articulated reasons with regard to disciplinary matters, as we stated earlier. The board will also continue to remain in closed session up until tomorrow at 10 a.m. So the board will be convening in the morning at approximately 9 o'clock to continue in closed session with regard to the disciplinary cases articulated in item 17. So we wanted to share that with folks here publicly, given the volume of work in closed session that we have to accomplish. And tomorrow as well, we'll gavel in at 10 o'clock, but then we'll also return into closed session at that point for our executive officer evaluation conversation. So just wanted to share that with folks for tomorrow. With that being said, this afternoon, we are going to conduct a hearing on changes to the board's continuing education requirements. And in conformance to the Board's Practice Act, continuing education is now referred to as continuing professional development, or CPD. The regulations discussed today will outline how a licensee can meet the requirements of CPD for purposes of license renewal. Before I open up the regulation hearing, I'm going to ask that Drs. Phillips, Horn, I will ask that Dr. Phillips provide background on this information, and he will also be joined by two former board members, Dr. Horn and Dr. Gallardo, to provide some historical background on these regulations. And before Dr. Phillips starts, we're actually going to have Ms. Sorick actually provide a procedural overview of how this policy came to be, and we'll go from there. And then we'll open it up officially for regulation hearing. So Ms. Sorick, please.
If you can just give me 2 minutes, I'm just pulling up that document.
No worries. Actually, Mr. Glass-Steagall, since I have you here, as well as Mr. Jackson, I just want to take the moment to welcome Mr. Jackson, who is with DCA Legal Review. He's our co-counsel with regard to regulations. Welcome, Mr. Jackson. And go ahead, Mr. Jackson. Sorry, I just noticed your mic.
I just want to say thank you, Mr. Chairman and Mr. President and members of the board. So I'm here for you.
Great, thank you. And Mr. Glass-Steagall, I just want to clarify that while Ms. Sorick and Dr. Phillips, Horn, and Gallardo make some comments that this can occur before I formally open the regulation hearing. Is that correct?
I believe so, but I will defer to Mr. Jackson.
I don't see a reason why it can't, so it should be fine.
I love it. This is fantastic. We have 3 attorneys on the phone call today. This makes me feel very protected legally. So we're going to have Ms. Sorick share some comments. In the meantime, Madam Moderator, if you see the names Jacqueline Horn or Miguel Gallardo, please go ahead and do promote them to participants if you see them in the attendees list.
Okay, just to give the board and members of the public a little bit of historical context to this regulatory hearing today, I'm just going to kind of identify some important dates and actions that the board took in furthering this policy along. So in 2012, the board was presented with a new model for continuing education by the Association of State and Provincial Psychology Boards, or ASPBB. In 2012, the legislature asked the board to discuss with the committee its efforts to date to address continuing competency and what it expects to accomplish in near future regarding this issue. The board's response to this was that it was working to replace the single requirement of traditional continuing education courses with a more robust continued competency model, which we believe will further ensure the continued competency of California psychologists. In 2015, the board noticed a regulatory change that established a framework for CPD. Many comments were received, so the staff worked with the board to make more specific how to comply with the proposed regulation through documentation and verification. In 2017, the board's Sunset Extension Bill established the 4 different categories of learning activities that met the requirements for CPD. In 2017, in June, the board approved language for noticing. Board staff drafted the package and submitted it to DCA, or Department of Consumer Affairs, to start the initial review phase.
Thank you, Ms. Soros. Really appreciate that. Dr. Phillips, could you share some background as board chair emeritus and the veteran on this board?
I'd certainly be glad to. And let me preface my comments by saying I greatly appreciate the often thoughtful feedback and concerns of licensed psychologists, institutions, and professional associations regarding the proposed continuing professional development regulations. Some requesting changes to implementation dates and how to comply questions will come as a natural consequence of educational efforts and necessary adjustments to the timeline due to delays occasioned by the careful review of these regulations by multiple state agencies, the board, Department of Consumer Affairs, and others. It has never been the intention of the board to leave licensees in the dark. As the proposed regulations are rolled out at a later date, and with the offered assistance of professional associations, we will do our very best to help you understand the regulations and the best ways to adapt to and comply with the change system. Having served on the board since 2013, I'm likely more aware than any current sitting board members of the extraordinary efforts made by the original, which I think was called the Continuing Education Committee at the time, under Dr. Miguel Gallardo, and the Licensure Committee chaired by Dr. Jackie Horn, the board, its council, and its highly capable staff to consider the concerns of licensees regarding these changes. As a result of significant earlier comments, significant alterations and adjustments were made to the original proposed regulations to accommodate the expressed concerns, most of which have been actively considered and addressed prior to this hearing. In 2015, after years of working on the regulations, the board made the decision to withdraw the proposed regulatory package and make substantial modifications based on licensee concerns, including a substantial increase in the number of hours of sponsored continuing education, which will be considered to reach a total of 36 hours of continuing professional development, and the addition of categories such as self-directed learning to ease the perceived burden on some of our licensees. One topic that needs to be addressed is why this change is being made. As pointed out by Dr. Greg Niemeyer in his comments on the proposed model, the sole reliance on the talking heads didactic continuing education model has proven to be an ineffectual means of gaining some measure of confidence in the continued competency of licensees. Competency is not a fixed quality that one obtains and then moves forward across time with the practitioner, but rather requires an ongoing engagement with the field and colleagues to best maintain optimal competency and knowledge. It requires some measure of interaction with your colleagues, peer feedback, the acquisition of new knowledge, and a dedication to ongoing training throughout the professional's life cycle. For instance, arguing that a long career in psychology is an assurance of a fixed state of competency does not pass muster. While I respect and applaud the contributions of older colleagues to the field and to the well-being of the public, I do not feel we are asking an extraordinary amount of any practitioner, no matter where they are located, their age, or their circumstances, to provide proof of their continued competency by devoting 36 hours every 2 years to a combination of activities, many of which can easily be conducted by phone, over video, or in self-directed efforts. For instance, a hypothetical practitioner could take 27 hours of online continuing education, engage in 6 hours of self-directed learning activities, and engage in 3 hours of peer consultation with one or more of their colleagues by phone, by video, or in person to complete their CPD requirements. The hours and the requirements of the regulations have been substantially adjusted to take into consideration age, disability, personal circumstances, and geography. To argue that this will drive a licensee into early retirement either underestimates the dedication of our more senior colleagues to their betterment as practitioners or betrays an unwillingness to adapt to modest changes in what is being required of licensees as we move forward. Similarly, claiming the new regulations deny consumers access to care because 9 hours over a period of 2 years will be devoted to something other than 9 hours of traditional continuing education seems disingenuous at best. It is ironic in a field that is dedicated to the betterment of others and the promotion of change that resistance to any change is the hallmark of a significant proportion of the feedback we've received in the context of this now almost 10-year process. At times, it seems there's a hyperbolic quality to some of the reactions to the proposed changes, despite the substantial flexibility that the model provides to demonstrate some measure of effort to maintain competency through continuing professional development. We have heard you, and we continue to hear your concerns. We've engaged in a transparent process of considering those concerns as best we can in order to provide you with a workable system of moving forward. The object here is to guarantee the assurance of quality psychological services for consumers with due consideration of licensees' concerns, but change is inevitable if we are to continue to evolve with a body of knowledge that suggests continued and sole reliance on a sponsored continuing education model is not the answer for the ongoing maintenance of competency. I applaud those of you who have relied on extraordinary amounts of continuing education and other professional development activities to ensure your ongoing competency. But as a board, we must also consider those who are not equally dedicated to such efforts. Our regulations must ensure that they too engage in more than a minimum and do not operate in an isolated vacuum without any meaningful interaction with their peers so as to ensure the greatest likelihood of minimum standards and efforts toward competency in the best interests of consumers of psychological services in the state of California. That is the board's primary charge, to protect consumers, and the one to which we continue to dedicate our primary efforts. Thank you.
Thank you, Dr. Phillips. I would now like to invite Dr. Jacqueline Horn to offer comments. Dr. Horn is Board President Emerita of the Board of Psychology and most recently on the board chaired our licensure committee last year. So Dr. Horn, could you please share some insights into the hearing that we're about to embark upon today?
Yes, I can. First of all, I want to thank the board for having me come and talk about this. It's been a long time coming. I was asked specifically to talk about the research that led us to these, to develop these guidelines or continuing professional development regulations. And so I'm going to start with something that Dr. Phillips talked about, which comes from Dr. Greg Niemeyer, who is a prominent researcher in the field of continuing education and continuing professional development. And that is that one of the things we learned as research started to come out about continuing education was that traditional means of continuing education, that is somebody lecturing to large groups of people typically, is effective for presenting information, but not effective at all in terms of changing behavior, having that information be absorbed, and also in terms of continuing competence. But, and I'm just going to give a little caveat here. As y'all know, there are a number of people when the board does its audits for continuing education, there's a certain percentage of people who haven't met the requirements. And in the broader literature, not just talking about people in California, about 25% of people who don't have, I'm going to say, well, about 25% of people actually don't get the required continuing education. So one of the things that has been looked at in the literature is what is going on. Why are these people, even with mandates, not getting the required continuing education? And so one big reason is that learning styles differ. And so people learn best in different ways. And so one of the things this model does is it gives the opportunity for the different ways that people learn to be, I'm going to say, accommodated through this continuing professional development model. Another thing that that the literature has shown up, or the research literature has shown up, is that isolation. When people are in practice and relying on, I'm going to say, traditional forms of continuing education only, they become more isolated. And this doesn't mean having to be in person or in the same room with somebody, but it means that interaction with peers and colleagues that begins to happen as we adopt different methods for learning. So what does the research say? First of all, I want to tell you there was a pretty big study looked at hundreds of psychologists across the United States asking what helps them best to maintain competence. And they identified two things. One, talking to colleagues. Two, reading a book. And they felt that that was the most helpful for them. And so peer consultation that we've talked about, self-directed learning that has been talked about and is part of the regulations, or even study groups are kinds of things that psychologists have identified as helping them learn the best. But what do we know? Variety in the kinds of activities help people not only get exposed to the knowledge, but then begin to retain that and then translate that into practice. Number two, activities that occur over time. So it's not a 1 day or 2 day class maybe on a particular topic, but that it happens, the activity occurs again repeatedly over time. So study groups, again, peer consultation, activities like these help people not only, not only do things begin to stay learned, but then they begin to be translated into practice. And then another important thing that we know is that interactions that occur over time with feedback help people change things. So getting the feedback is central to their beginning to increase their competence or their skills or solidify their competence or their skills in certain areas. And one of the things that we know, and psychology education really pushes for, is evidence-based practice. So what's being taught to graduate students and in graduate training programs in psychology is practice what's evidence-based. And so this model of continuing professional development is evidence-based. It's based on what we know helps people to, again, retain the knowledge and then begin to change their practice. So in the same ways that good continuing education or continuing professional development, it wants to know what's learned so that people can adjust presentations or adjust what they do. We also know that when psychologists get feedback from clients of theirs, and this doesn't have to be in therapy, this can be in organizational settings, but they get feedback about what's been helpful and what hasn't been helpful. That allows the psychologists to change their behavior and to offer something better or modified that's helpful. We do know that when we monitor our interventions, either with clients or whoever, that leads to better outcomes. So, and in therapy, which many psychologists in California do, it leads to better outcomes and more positive outcomes. And it's good in establishing the therapeutic relationship. It helps in that regard. So in the same way we use evidence-based practice and teach evidence-based practice, again, I want to say that the continuing professional development model is based on evidence. So thank you again for letting me say this. I think I hit all the most important research findings in the field at this moment. So thank you.
Thank you so much, Dr. Horn, and welcome back. And Dr. Miguel Gallardo, Dr. Gallardo is a former president of the California Psychological Association. He's also a former board member of the Board of Psychology. Welcome back, Dr. Gallardo.
Thank you. Thanks very much for the invitation. Appreciate the time, and happy to see this moving forward and hopefully moving through. I was asked to talk a little bit about my involvement in the regulations and then also the cultural diversity and social justice requirement. And so I served on the board from 2010 to 2016 and then was vice president from 2013 to 2014. And it was when this was presented to us, it was the committee that I was chairing at the time, which Dr. Phillips referenced earlier, that really took on the brunt of the initial work with regards to developing, what this could look like for the state and for psychologists and also for consumers. And so that was my involvement at the outset. And then in the process of really developing these CPD guidelines, we felt that it was important to really think about how we could, if we're talking about thinking about the protection of consumers in California and looking at some of the literature and research around health disparities, treatment outcomes, particularly for ethnocultural communities and other communities who are, unserved and underserved. We felt like it was a good opportunity for us to incorporate some cultural diversity and social justice requirements in these guidelines. And I think, for those of you who are on the board and even if you haven't been on the board, I think, psychologists, we don't like to be told to do things and, to increase the number of requirements that we have, et cetera. And so as opposed to, requiring that it had to be a specific course or in a particular way, we thought that it would be important that, at least 4 hours of that time frame of the renewal for those 36 hours at a minimum would be, connected to and relevant to, cultural diversity and social justice requirements. And hopefully, I think back then, and I think it was not only was it past due, but it was obviously very important. And I think even now at this moment in time, interestingly enough, we're at one of our maybe most divided and divisive times in our country, and I think we're seeing a lot of issues that are have been around for a very long time that are affecting the lives of communities across California. California is there's no majority racial ethnic group in California. We have a pretty diverse group of community members here in California. Latinx communities make up the majority in California, and then it goes from there. So we don't have a majority racial ethnic group in California. I think that's important because I think that talks about who is receiving services and are we being prepared to provide services to the folks who need them most. And not just around racial or ethnic issues, but also thinking about, LGBTQ communities as well. 40% of homeless youth in California are from LGBT communities. And so, there are intersections here of cultural variables and social identities that communities here in California are facing. And I don't think our training programs are doing enough, to really, I think, prepare those next generation of folks who are coming out to provide services. I think it's certainly getting better, so I think there's still a lot of work to be done within even just the training and education communities. And then for those of us who've been out for a while, and for folks who've been out longer than me, I think we even got maybe less of some of that information when we were in our training programs, and really, thinking about what that may mean for us in our implementation and in practice. And so there's a lot of research that talks about health disparities, access to treatment, treatment outcomes, et cetera, that really talk about the need for us to be better trained to meet the needs of diverse communities. And for a long time, I've heard a lot of psychologists say that, addressing some of these social issues that communities are facing or whatever it may be, are really maybe, how much they fall in line with what we should be doing as psychologists. And I would argue that it's part of our professional responsibility to do this work. And I think as a board, we felt like we had a responsibility to ensure that we were doing everything we could to really put front and center that this is important, and we think this is something that we need to commit more time, energy to, and hopefully continue to make more central in everything that we're doing. So I think for a long time, a lot of continuing education providers have requested that folks offering continuing education offer and integrate diversity issues and social justice issues in their content. And to be honest with you, sometimes what that looks like is a slide or two, in their presentation, or a very brief mention, and it's not adequate enough. And so we felt like we needed to be doing more to really prepare licensees and those who are going to be delivering services, and also thinking about consumers who are incredibly diverse here in the state of California. So I was asked to speak for like 2 or 3 minutes. I think I took my 2 or 3 minutes, so I'll stop there.
Thank you so much, Dr. Gallardo. So at this point, what I'm going to do is I'm going to move ahead with the process for the regulation hearing. And for those purposes, I just want to state that my name is Seiran Fu, and I'm the board president of the California Board of Psychology, and I'll be conducting this hearing on behalf of the board. Today's date is November 19th, 2020, and this hearing is beginning at approximately 2 p.m. This is the time and place set for the Board of Psychology to conduct a public hearing on the proposed amendments of regulatory sections 1397.60, 1397.61, 1397.62, 1397.67, and 1381.9 of Title 16 of the California Code of Regulations relative to continuing professional development. The purpose of this hearing is to receive oral and written testimony concerning the regulatory proposal. We ask that all persons in attendance who wish to testify provide their name. If, for any reason, you do not desire to provide your given name to identify yourself, you may do so. Providing the board with your name is voluntary, but for the board to contact or notify you of any further actions in this regulatory process, the board must be provided with a means of contacting you. To ensure fairness and a complete record and to enable the board to hear everyone who is giving testimony, the following procedures will be followed. This proceeding is being recorded. Please identify yourself by name and group you're representing, and if you wish to do so. As mentioned, this is voluntary, and the board requests that you do so in order for us to provide you with any modified text as required by the Administrative Procedure Act. If necessary, the amount of time each person has for oral testimony may be limited. All written testimony should be submitted to the board. If you agree with another individual's testimony, you may simply indicate your agreement on the record and need not to repeat testimony. Written testimony may be summarized orally, but please do not read it into the record. The board will not respond to objections or recommendations at this hearing, but may ask questions to obtain clarification. Responses will be provided by the board at this meeting after the hearing has concluded when we consider adopting the text as noticed. The board also reserves the right to provide responses at a later board meeting if the board determines that additional time is necessary to respond. In addition, responses will be included in a final statement of reasons that will be filed with the Office of Administrative Law and posted on the board's website. A complete copy of the rulemaking file will be available for review at the board's office in Sacramento. I now ask that our moderator go ahead and please open up our comment section on our screen. And if folks would like to make a public comment with regard to this regulatory hearing, to go ahead and please follow the instructions on your screen and type on your screen, I would like to make a comment. For those who are joining us for the first time and weren't with us this morning, please note that asking a question directly into this Q&A box it will not be answered. The Q&A box is strictly for you to identify that you would like to make a comment. And I'm going to continue to hold this box open for folks so that they can participate in this. So now that I've seen responses come in, I'm going to ask, sorry,
This is the moderator. We'll go ahead and start with our first individual who has requested to make a comment. Elizabeth Winkleman, I am unmuting your microphone now.
And thank you so much, Madam Moderator. And I'm going to, based on what I'm seeing here, I'm going to establish a time limit of 5 minutes per person, given the, since we have time for folks and the number of folks responding so far is allows for that. So I would like to.
Just to clarify real quick, would you also like me to give a 30-second warning?
Oh, that would be fabulous, Madam Moderator. Thank you for offering.
Wonderful. Okay. Elizabeth, you're unmuted, and I'll go ahead and start the timer now.
Okay, thank you. Hi, this is Dr. Elizabeth Winkleman. I'm the Director of Professional Affairs at the California Psychological Association. Appreciate the opportunity to make some comments. First, I wanted to say that I am following up on written comments that were submitted by Dr. Joe Lindercrow, submitted on behalf of CPA. And I wanted to note that in the meeting materials, in the hand carry materials, there was only one page of the letter that the 3-page letter that we submitted. So first, I wanted to just confirm that the board has received our full letter, because it's not actually reflected in the materials that are in the hand carry materials right now.
Madam Moderator, could you pause Dr. Winkleman's time so that we don't eat into it while we take a look at it? And I'm going to ask that board staff confirm. I recall seeing all 3 pages, but I'm not sure if I recall seeing those 3 pages because it was shared with us directly by email or if it was in the board packet. So we're going to ask staff to investigate that. But Dr. Winkleman, I do recall and reading and rereading the full letter that you provided, and we're going to ask staff to confirm that the full 3 pages were included.
Okay. Okay, thanks very much. And just also so that others who are looking at the materials, I want them to also be able to, if that can be corrected later, so that they can also see the full materials, if possible. So I wanted to follow up on those and say we appreciate the intent of encouraging various types of continuing professional development learning activities. However, we do have several concerns about the proposed regulations, and also we've heard a tremendous amount of concern from many psychologists about various aspects of the regulations. And some of those people have obviously submitted written comments as well. Our main concerns, which I believe you are going to be addressing, one is the implementation deadline, which seems right now it's January 2021, and we're requesting that it be delayed to 2022, January 2022 or later. Pretty sure you're going to address that, but I wanted to mention that. And then the second main concern is we would request that you consider allowing increased flexibility in how people obtain the CPD hours. In particular, we request that you consider allowing all of the CPD to be earned either through sponsored continuing education or through a combination of sponsored continuing education and self-directed learning. Now, the reason for this is I realize that for many people, it would be no problem to obtain some of these other types of continuing professional development activities. However, we've heard from many people that it would be a hardship for them, in particular, older psychologists, disabled, part-time practitioners who may work in a different role, like a manager, a program manager, wouldn't necessarily fit into these type of categories, people with financial concerns. And it also depends on person's time in their career. For example, they may be maintaining a license but have a small and specialized practice. So I think it would be a lot, there's an argument to be made that it would be much more fair to allow people to have more choice in how they complete these requirements and allow people to do the learning activities through all through traditional CEs or a combination with traditional CEs and self-directed learning. Also, I wanted to mention that with the traditional CEs, the in-person classes often, of course, involve interaction with other peers. So as it currently stands, even with the traditional CEs, there is, in maybe 20 years ago, people would just sit in a lecture hall, but there is often breakout sessions and interaction with other people, particularly before coronavirus, when we could do more actual in-person instead of virtual in-person learning. And also, although there's evidence that people, and maybe I've missed something from Dr. Hornan, she can correct me if I'm wrong, but I also don't think that there's evidence that people who are doing traditional CEs are more likely to actually cause harm to the public. or that there's any difference in rates of harm to the public between states that have
30 seconds.
Oh, okay. And then finally, in our notes, there are a number of areas which we would request that you provide clarification. I don't have time to go into those in detail, but there are several areas that we think that would need additional clarification. All right, that's it. Thank you. Please consider our comments and concerns of our organization and our members.
Thank you so much, Dr. Winkleman. And I did confirm with staff we did receive the full letter. What happened was that in organizing the PDF file, a portion of your letter was actually moved to pages 75 and 76 of the PDF. So Mr. Glass-Steagall will make sure that when we provide updated comments based on today's oral testimonies, that we will re-update that document so we bring that first page, which I believe is on the first few pages of that hand carry, and reunite them with the other two pages. I should make a note that those two other pages on page 75 and 76 are properly notated to say that it is from CPA, and Dr. Joe Lindercrow's signature is on the third and final page. Madam Moderator, back to you. Thank you.
All right. This is the moderator speaking. We'll move on to our next individual who has requested to make a comment. Individual identified as Eric Bayan. You'll be given 5 minutes to speak and a 30-second warning. I am unmuting your microphone now.
Thank you very much for the opportunity to address the board on this issue. My name is Eric Bayan. I am a licensed psychologist in California, based with the Adult Consulting Group in San Francisco, although I am speaking as a representative of just myself. I'm a consulting psychologist, and so we do my work with organizations and executive individuals in the business field. I want to echo and reinforce the comments that were just delivered by Dr. Winkleman, and I support everything that she said in full. Specifically, my comments are in regards to the number of categories that are going to be now expanded to have for allowed continuing education, professional development activities. I absolutely applaud the board's effort in expanding these categories from the one traditional sponsored continuing education group to now a cluster of 4 categories. I think it's wonderful to allow individuals like psychologists to be able to utilize their involvement with these additional activities as part of their continuing education requirements on a biannual basis. So I think that's great. Two things that I have concerns about are that it's mandated that psychologists for their licensure renewal need to have a minimum of 2 of those category hours from those 2 of those categories apply in their 36 hours. I would like it so that they could have as many or even as little as 1. And again, echoing Dr. Winkleman's comments earlier, that if a psychologist has the ability and the wherewithal and it fits their practice and their ability to address their continuing education needs, to get all of their continuing education licensure hours under the sponsored continuing education category of 36 hours instead of 27, I think that they should be allowed to do that. But I also believe that psychologists should have the opportunity, if they don't want to do all of their hours of 36 in that category, that yes, now they would have the opportunity to be able to do this this hour requirements in other areas as these proposed regulations now expand on. So that's the first thing. So specifically in section 1397.61 letter E, in the first paragraph there, the sentence that begins with the exception of, my request would be to strike that sentence, leave everything else in letter E's portion of that section alone, proposed regulation, but just that one sentence, take that one out. And then the second thing would be in section 1397.61, letter H, number 1, basically just change the number from 27 to 36. And again, the rationale for all of this is essentially, we're all licensed psychologists. We're all responsible adults. It's great that the board is giving latitude to individuals to expand the types of experiences that would count for licensure renewal hour requirements. But I think that in order to mandate that they have to do it across a number of different areas is a bit limiting. I would rather that it be expansive, give people the opportunity to go ahead and pick and choose what works best for them. And that's pretty much all I need to say. Thank you very much for the opportunity to comment.
Thank you so much, Dr. Bayan. Madam Moderator?
All right, we'll move on to our next individual, identified as Karen Shore. Karen, you will be given 5 minutes to speak and a 30-second warning. I am unmuting your microphone now.
Okay. Thank you very much, and I appreciate being here and especially hearing what Dr. Phillips and Dr. Horn was saying, because I did learn something. I wanted to also thank you for changing some of the requirements, boosting it to 27 with the CE, adding self-directed learning, taking out what I believe you did, take out those documentation logs, and allowing all CE to be taken online. That's really, all those things are really helpful. Dr. Phillips, what you said, I think, may point to some problem in the wording of the definitions, because a lot of people's protests have to do with the way professional services, peer consultation is worded, and I wasn't prepared to see this, but I think there's something about it having to be part of an ongoing group. And when you said, it's not too much to ask that you do 27 hours of CE and 6 hours of self-directed learning and then 3 hours by phone or whatever with a peer, I agree with that. My impression, though, from the wording and the definitions have been that you can't just say, okay, I'll have, I need to call somebody to ask this question or that question or that question, that it's supposed to be part of an ongoing set of meetings. So maybe you folks can clarify that, and if it's what Dr. Phillips says, then yeah, most of us do talk to each other occasionally, but it's not a routine, ongoing thing. So if it can be as needed, then absolutely, I'm agreeing with you. The other thing about what Dr. Horn says that also I'm very familiar with the research, and part of taking so many CE, which I know you're familiar with from my comments that I do, sometimes upwards of 100, 120 per licensing period, that does meet this research that says, it's the one-off didactic talking head doesn't do it. I completely agree. But the research that says when you focus on something over time, and that's what a lot of us are trying to do, building a specialty, enhancing a specialty, taking something in the same focused area over time, it does exactly that. And it's also not so true anymore that most programs, hardly any of the things I've taken have just been a talking head. Almost all of them that I've taken in the last 5 years or so involve interactions with not just the presenter, but with each other, and breaking up into small groups, practicing new skills, getting feedback on what we're doing. And so I'd like you to consider that CE, the assumption that we're all doing one-offs and they're all talking heads is just not true anymore. There's just no more school that we can go to, so we're trying to create our own schools, basically. The unintended consequences that I experience are that there's under-regulation for that 25% that Dr. Niemeyer calls the CE minimalists, and maybe a bit of over-regulation for those of us who are very highly motivated. But again, if you can clarify that the consults don't have to be part of an ongoing group, then that could help a lot. The things that I also wanted to do would be to expand some of these categories, especially the peer consultation. And I've given you a whole list. I'm not going to go through them all because there's a lot, and I understand you're supposed to read everything. I do want to mention also, last month I had some consults with by email with Dr. Niemeyer to update want to get his updated thinking. And he is saying that the field is going away.
30 seconds.
Oh my God, okay. If you could add clarifications, can we include our book clubs? Can we include our special interest groups? Can you take a look at, if you're not going to raise the 27 or the self-directed learning, can you allow for those of us who do 40, 45, or 50 or more with 20 or 25 in a very focused area to do exactly what you're saying? That would be helpful. I do spell it out in my stuff, and I hope you'll read that. Also, can we include consults with lawyers and consults with, for example, CPA's ethics committee? It's not mentioned. It doesn't sound like it is, but those are the kinds of things that increase our confidence. So please do take a good look at some of my recommendations, including my concern about that 25% and maybe require a minimum of 20 CE for everybody so that you don't have somebody who's barely taken anything and is fudging some of the group consultations. All right. I think that summarizes it. Thank you.
Thank you so much, Dr. Shore. And I just want to point to the board members that Dr. Shore's written comments start on page 13 of your PDF with regard to the items here. So her full comments are incorporated on page 13 of the PDF. I do have a question for Mr. Jackson, or with regard to the clarification questions that Ms. Shore asked. Excuse me, I apologize, that Dr. Shore asked. Mr. Jackson, are those questions is it possible for us for Dr. Phillips to answer those questions within the context of the rules of this hearing, or should those questions that Dr. Shore posed be addressed at a later time?
These hearings aren't really supposed to be set up as question and answer sessions. They're more to take public comment, and then the responses will come will come later from the board.
Understood. Thank you so much for clarifying that. So, Dr. Shore, your questions with regard to that you made in your oral comments have been documented by board staff, and as a part of these procedures, the board has to respond to these questions that you've articulated during those oral comments. And of course, the written comments submitted also have a response as well. So thank you, Mr. Jackson, for that clarification on process. Madam Moderator, could you please turn to the next person?
Yes, this is the moderator speaking. Our next individual is Sean Mccall. Sean, you'll be given 5 minutes to speak and a 30-second warning. I am unmuting your microphone now.
Thank you. Am I being heard?
Yes.
Nice. All right, so I am Sean Mccall, licensed psychologist and attorney in the Bay Area. I sent an email to Mr. Glass-Steagall on October 5th at 10:45 a.m. So most of what I have is also there, but I wanted to put it on the record here, and that my focus is mostly on knowing what we need to know in order to stay in our lane and do what we need to do. So to that end, one of the things that I thought could be confusing for some licensees would be like APA or CPA kind of convention attendance. Does that count as sponsor-approved CEs, or is it like the 6-hour convention thing? And so understanding that some of the categories may have some overlap when there is potential for conflict between categories, being able to clarify so that the licensee understands what the obligation is. Another thing, maybe I think that to echo some of what Ms. Winkleman had previously indicated, I think we do need to understand some of the reality of Corona, as well as I think that I'm going to say likelihood of us going through this probably in the future, unfortunately, with something different. So, to that end, I think that there could be some consideration about with some of these traditional conferences where there's the multi-sessions where you get to kind of filter back and forth and everything and socialize. Those, you don't get to choose the multiple sessions these days when they're done online, right? That they appear to be much more of the just one presentation that could be I think somewhat concerning in that that's a change from the traditional format that deviates from the idea of being able to go in and out of sessions for conventions. So being able to let people know that, if, what would be a convention looks more like a course because of the way things go with, governmental restrictions on movement, then, what bucket does that fall into? Similarly, I would think that maybe even attendance to the Board of Psychology meetings like this, when they're done virtually, would be good to consider, as far as I understand the current requirement being in person. But what does that mean in the coronavirus time and another kind of pandemic time, as well as could we even maybe add in there that virtual attendance to a BOP is okay? And as an extension to that, like my email that I wrote to Mr. Glass-Steagall, that is participating, I think, in the dialogue, right? When I look at, things for public comment and make a public comment. So, does that go in the self-directed learning category? Is that just a throwaway and something that I'm doing for, my own edification? Might be good to understand what that kind of participation in the process does or doesn't do towards counting towards requirements. Another thing could be, I'm a former SFPA, San Francisco Psych Association President and Ethics Committee Chair. I was a treasurer for Santa Clara County, but right now I'm doing stuff with the Association for Family and Conciliation Courts as part of their continuing education committee. So, that works a lot with the intersection of psychology and the law in children and divorce matters, which I think we can all agree is contentious. And needs to have good education, but that is a professional leadership organization. It would be good to be able to help, I think, define what kind of professional leadership organization participation counts for being able to, tick off that box, if you will. Then I think finally my comment would be with some of the new things like the ethics and diversity. The ethics and diversity, social justice issues, as well as our legal issues, understanding that some of those may also be captured, and there may be some kind of dual credit, if you will, for both that as well as the sponsored CE, being able to satisfy both requirements kind of simultaneously. I yield my time.
Thank you so much, Dr. McCall. And for the board, I want to draw your attention to Dr. McCall's written comments on page 130 of the PDF. His full submission reflecting his written comments are on page 130 in our PDFs. Madam Moderator.
All right, this is the moderator speaking. We'll move on to our next individual who's requested a public comment, Catherine Campbell. Catherine, you'll be given 5 minutes to speak and a 30-second warning. I am unmuting your microphone now.
I actually didn't ask to speak during this section, but thank you.
All right, this is the moderator speaking. It looks like that was the last individual. Oh, I apologize. We got another comment.
Please.
from Joe Linder Crow. Joe, I will be giving you 5 minutes to speak and a 30-second warning. I am unmuting your microphone now.
Okay, thank you. Thanks, everyone. Dr. Joe Linder Crow, I'm the CEO at the California Psychological Association, and indeed, this has been a long road. We have at CPA been involved in working with the board, working with the committees over the last several years in the development of these regulations. I just want to make a couple of closing comments, of course, supporting what Dr. Winkleman said about, and referring the board again to the letter that we sent. I think that we have been trying very hard to do some outreach to our members. We held a virtual conversation on this topic, and I developed a document that literally walked through page by page and section by section for CPA members so that we could do our best to really explain all of the nuances of the regulations. I think one point I would like to just reiterate is that the implementation date, I think we might all can agree, may need to be set forward. We will continue to do outreach. The intention of these regulations always had about a year that we intended, and the board intended, as I recall, for outreach to licensees, so that by the time the implementation date came, everyone would have a very clear understanding. And based on what we have learned from our members and the number of questions and the areas that need clarification, we really based our letter on the comments that we have gotten. And I think an additional year would allow us and the board to do significant outreach to clarify those things, which will, I'm quite sure, reduce the burden on the BOP staff once these go into effect. There are a lot of specific questions, but I think the areas that we have pointed out are the most frequent questions that we have received. So again, thank you for letting us comment on this. We certainly stand ready to help do outreach to licensees throughout the state of California, so that when you implement these, hopefully the number of questions will be reduced through the clarifications that you can make at this point. I think some of these clarifications, Dr. Mccall just mentioned the virtual nature of this, and I just want to recognize that some of these clarifications need to be made just reflecting the environment. When these were first written, we weren't doing so many virtual things. So some of these will be easy and obvious, like noting that if meetings are only virtual, like the CPA convention will be next spring, and the Board of Psychology meetings are now, clearly that needs to be made clear. And we've offered some language for the board to consider, simple clarification language. So thank you again. We certainly stand ready at CPA to help, provide education about these. Thank you again for making the adjustments that you've already made based on the comments that you've received in the past. And we ask again that you consider the suggestions that we have made in our letter. Thank you very much.
Thank you so much, Dr. Joe Linder Crow, for your work and the work of your team as well at CPA. I'm going to ask, actually, before we close out this section, one of the things I mentioned early on was that while the board may not respond to objections or recommendations at the hearing, we certainly can ask questions to obtain clarification. And so I wanted to check in with our board members to ask if they have any clarification questions based on what you heard. And we can then ask Madam Moderator to be in contact with the person to which you have a clarification question with regard to their comments. So if you're a board member with clarification questions based on what you heard, please feel free to raise your hand or unmute yourself. And I'm scrolling through slowly and back just to make sure I don't miss anybody. All right. while board members potentially unmute themselves or raise their hands, is there anyone else who wishes to testify at this time? Right. Seeing no further board, Ms. Cervantes, I see you've unmuted yourself. Do you have a clarification question, and to whom would you direct your question to?
Yes, I have a question, and I think this may be a question for staff. I didn't see this information in my documents, but do we have an analysis about a potential cost increase or cost decrease to licensees with this regulatory change?
If I may weigh in?
Yes, Mr. Glass-Steagall.
Thank you. There are a couple different sections where we have to discuss fiscal effects. One, it's in the notice, also in the initial statement of reasons, and then there's also a special document called the Standard 399, which has to go to the Department of Finance, which lays out costs associated with any regulatory package.
Ms. Cervantes, if you turn to item 13, the memo for item 13, dated October 27th, under attachment A, the notice of proposed hearing, if you turn to section C, consistency and compatibility with existing state regulations, there is a cost impact on representative private person or business, as well as an analysis on effect on small business, and the assessment of economic impact analysis. That would be pages 6 and 7 if you're looking at that item individually and separated from the larger packet.
Okay. Okay. Oh, okay. Okay, thank you.
All right. Seeing no further, sorry, I see Dr. Shore has additional comment, Madam Moderator. Just want to clarify that the question section isn't really it's more an indication of whether or not you're speaking for public comment. But if there is an objection from board members, because Dr. Karen Shore has made an additional indication on QA, if there's no objection, we could ask Dr. Shore to ask her question out loud. Dr. Shore, recognizing that you've exceeded your 5 minutes.
All right, this is the moderator. Would you like me to go ahead and unmute her microphone?
Seeing no objection for the board members, please do.
All right, Karen Shore, your microphone is being unmuted right now.
Okay, thanks a lot. Yeah, it just, when I was saying what Dr. Phillips was suggesting to make up that extra 3 by 3 hours of consult with somebody, the definition under peer consultation says structured and organized interaction. That's the definition, and that to me would not include me calling a lawyer for a consult or calling a colleague for a consult on an as-needed basis. So I was curious to know if the definition can be clarified or changed to include consultations on an as-needed basis and for a fee or not for a fee, because calling a lawyer is certainly something that we like to do to protect the public, but doesn't sound like it's included in this definition either.
Thank you so much, Dr. Shore, for that additional comment. I'm asking that staff please receive this comment and ensure that it's appropriately responded to as a part of this process. So seeing no further persons who've indicated that they're interested in testifying at this time, the time is now 2:39 p.m. With no additional individuals requesting to speak, this hearing is now closed. So what I'm going to do actually is I'm going to ask either Mr. Jackson or Mr. Glassbeagle to briefly explain what just happened and where we're going next in terms of next steps, so that folks understand, both for members of the public and also board members, what just happened and what are the next steps for all of us. So Mr. Jackson.
Okay, thank you, Mr. President. And what just happened was that as part of the procedure, the regulation process includes public comment, and it's both written and oral, as we just had just now. The initial public comment is 45 days, wherein the board will accept written comment from individuals, entities that want to advise the board of concerns, of comments, of things that they like or dislike within the regulation package. And so that was closed 2 days ago, and the board has just heard the oral portion of the comments, which allow the board to gain more information than was just collected in the letters or written comments. There were 55 written comments for a total of 155 pages that were received by the board, and those comments were distilled into the portion of the board packet that was received today, I believe, or last night, and that includes a listing of the part of the comments that were made. It includes a breakdown of those comments into various classifications, so that instead of just having to read 155 pages of comments, the salient points of those comments have been distilled into what the board has received and what I believe is available to the public. And so, and we grouped those, as I said, so that it would be easier to read them and to put them into various buckets for discussion and in order to respond to them. So that's what's just happened. After this, if the board determined a necessity to change the text of the regulation, those changes will engender a 15-day comment period. There will not be an additional oral comment that can be made to those, but the public or any licensees or anyone can write the board just as they did during the 45-day comment period, and they can respond to the revisions only made during that 15-day comment period. So they can't go, for example, and comment on what was included in the 45-day comment, but they are allowed to comment on the specific revisions that the board might make, that if the board makes them today, on those revisions. And so it's a narrowing process, not a widening process, so that the board will not have to open up overall comment just on those changes that would be made today.
Thanks so much for that helpful clarification. So, board members, do you have any questions for Mr. Jackson or Mr. Glassbeagle about item 13 and the regulation hearing, the regulatory hearing we just had? All right. I'm not seeing any microphones going unmuted or hands raised. So, per Mr. Jackson, the consideration of these comments will happen under item 14. Is that correct, Mr. Jackson and Mr. Glassbeagle?
That is correct.
And to make sure that we give a staff time to respond to the comments that we heard orally today, I'm suggesting that we actually hold item 14 for tomorrow, so that staff can prepare can intake the oral comments submitted today and prepare a response. And then we will review the attachment that Mr. Jackson referenced with regard to the summary of those items. to go ahead and then work through them tomorrow for item 14. So I would just want to make sure that if there aren't any objections here from board members with that plan, I just want to make sure that our public who are in attendance know that we will take up item 14, which is to respond to the comments submitted orally and in written format tomorrow to give staff time to process the comments today. This time will also provide more time for board members to revisit some of those letters that we heard from Dr. Jolinda Crow, Winkleman, Shore, Mccall, and Bain in terms of their written submissions as well, should you please. So with that, we will hold item 14 for tomorrow, and we'll take up item number 15, which is our consideration of the telehealth practices. I'm going to turn this over to Mr. Glass-Steagall. Oh, actually, I'm going to ask that Dr. Phillips provide some historical knowledge because he has been involved with this as our chair of our telepsychology committee. So my apologies. Dr. Phillips.
Yes, there was a substantial concern on the part of licensees and professional associations regarding a lack of direction relative to telepsychology, which has obviously been a rapidly evolving field within the area of the more general area of psychology, and has become particularly important in recent months through the existence of the pandemic. So there was a process of distilling out of guidelines created by APA and ASPPB, or the Association for State and Provincial Psychology Boards, to kind of distill out what some of the important considerations are. In the context of doing that, the question of what types of interactions were permissible or not permissible relative to jurisdictional questions came up with some relative frequency. We have worked through some of those patterns. More concerns have been raised relative to that. And in an effort to address those things, the committee has met again, and staff has provided some revisions to the originally noticed regulations for us to discuss during the context of this hearing. We obviously recognize that this is an important area in which licensees do seek guidance. Some guidance we can provide, some guidance we cannot provide. We cannot tell you if you're running afoul of the laws of other jurisdictions. If you're sitting in another state, when the question comes up of, and you're dealing with somebody in the state of California because you're temporarily out of state, we cannot tell you whether, for example, the state of Tennessee is going to be okay with you doing that. That's not within our charge. It's not within our jurisdiction. But we have tried to better elaborate the various situations people might find themselves in so that they can give appropriate consideration to what their California license requires them to do, and also what other jurisdictions may or may not require them to do. So that's a very vague description. I think it'll be a lot clearer once we get into the specifics of the additional proposed language in response to the comments. Thanks.
Thank you, Dr. Phillips. So I'm going to turn this over to Mr. Glass-Steagall. Note that for this item, staff is requesting that the board consider the written comments received during this 45-day period and provide feedback as to whether the comments should be rejected or accepted, and any requested modification to the regulatory text. If there is an action item out of this, it will be that the staff is requesting that the board delegate to the executive officer authority to adopt the modified text in the absence of any negative comments, and continue with the process to finalize the regulatory package, including making any non-substantive changes if we get to that point. Before turning it over to Mr. Glass-Steagall, I just really want to express my gratitude on behalf of the board to both he and Mr. Jackson for staying up very late yesterday to receive and summarize all these comments that were received in our board packet. As you can see, it's a lot. So just our thanks to you, Mr. Glass-Steagall and Mr. Jackson, for going through all these comments. And of course, any unnamed staff that I'm not aware of, my thanks to you too, and would love to know who you are so we can express our thanks. Mr. Glass-Steagall.
Thank you, and that was, it's appreciated and very well said with the introduction, and I have nothing in addition to add.
Okay, so with that being said, do board members have initial questions for Mr. Glass-Steagall or Dr. Phillips?
I have a question. In reading over the comments, when the person has made a comment and then the board or the staff comment is that the wording has been revised to reflect that comment. I'm wondering if Mr. Glass-Steagall, you can say a little bit more about that. Is that reflected in the documents we have in our packet, or if you could tell us a little bit more about that process?
Absolutely. Thank you, Dr. Herbst. Yes, so after the comment period ended and the comments were summarized, staff sat down with the two sets, well, with the original notice language and also the changes from the committee, and came up with another document, which is the documents in your packet. They are attachments, modified.
E as in Edward.
Thank you.
Page 347.
Page 347. And those, any changes that were requested in the comments, if the response says that the changes have been incorporated into the language or the language has been modified to reflect the changes, that is reflected in there.
Okay, so is that the yellow or the blue? I'm just kind of looking at it. The yellow or the blue is, can you just explain to me? Oh, I see it up above. I see it. Got it.
I'm so sorry to interrupt the flow of the meeting. This is Will McGuire, Board Counsel. I just wanted to ask the moderator if she could re-promote Noreen Marks to panelist. She got kicked out of the meeting.
All right, Noreen, you're back up to a panelist.
And it sounds like, Dr. Herbst, that you saw the legend, and yes, yellow was Telepsych Committee and blue was the changes from the comments.
I did, thank you.
Are there additional board comments or questions at this time? All right, if not, I'm going to ask Madam Moderator, could you open up the public comment section so we can take public comment for item number 15?
All right, this is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a public comment on this agenda item, please click on that icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. Currently have instructions up on the slide for your reference. All right, and it looks like we do have one individual who's requested public comment, Elizabeth Winkleman.
Dr. Winkleman, please.
All right, I'll be unmuting your microphone now.
Hi, this is Dr. Elizabeth Winkleman, again, the Director of Professional Affairs for the California Psychological Association, and thank you for the opportunity to comment. I know I just have 5 minutes, so I'm going to try to be quick. We are very concerned about the proposed language for these regulations, including with, we don't feel that the proposed edits to the initial proposed regulatory changes sufficiently address our concerns. The main focus of our concern is that right now we need to be expanding access to telehealth services, not restricting it. And there's two particularly troublesome aspects of the proposed regulations that potentially restrict access. They're detailed in our letter, and I hope that all the board members have had the chance to carefully review the written comments that we submitted. To summarize, this is where the healthcare field is moving, is more telehealth, and we don't see any compelling rationale for limiting access to interjurisdictional telehealth in specific situations. So, and we are also very troubled by the continued use of the word resident in the proposal, in that, as we describe in our letter, limiting the access to interjurisdictional telehealth to residents of California would have potentially an unfair discriminatory effect on people who are not legal residents, including people who are here for a temporary purpose, such as college students, or people away from on a work assignment here, also immigrants who may not be documented, or people who are on temporary immigrant status. I also want to mention that no other state that I'm aware of has any regulations that restrict access to interstate telehealth based on the residency status or on having received services within the state first. And I also want to mention the BBS recently adopted rules that are similar to our suggested language. And basically our suggested language is that in the Section A, instead of trying to list specific situations under which people would have access to interstate services, that instead you would just limit them to, as in our suggested language, to when the interstate practice would be forbidden by the other states' licensing laws. I do appreciate your addressing, also listing the scenarios is very confusing and is going to lead to many, many questions. So I do want to say that I appreciate your addressing our other two concerns we mentioned about the trainees and also about international patients. And I hope perhaps if I don't use up my full 5 minutes now, that I can be involved in any questions that might come up about my comments and the type of scenarios where people would be harmed. The most common scenario, and I've heard this from many, many of our members, is a college student who is in California but has a residency in another state and then begins treatment here and moves back to their home state. I think the staff language would address it, but the initial committee language would not. And also, as I said, the current language doesn't, proposed language still leaves some gaps where interstate telehealth would be prohibited. And the bottom line is we're just very concerned about that. Thank you.
Yes, Dr. Winkleman, Madam Moderator. Oh, actually, I was going to say, do we have any questions for Dr. Winkleman at this time? And if not, Dr. Winkleman, can you remain on? Because I know I will have questions at some point. So if you could stay on, that would be fantastic.
This is the moderator. Would you like me to unmute Dr. Winkleman again?
Sure, that'd be great.
All right.
Thanks very much, Mr. Fu. I very much appreciate being able to participate in this discussion because it gets confusing very quickly between residents and in-state, out-of-state, temporary, permanent, and the provider and the patient. So I appreciate the opportunity to be a part of the discussion.
Thank you. So what we're going to, just as a matter of process, I don't see any questions immediately from the board now, but if we could just hang in with us, that would be really great. And I know that it looks like I actually suspect Dr. Elizabeth Gossett requested to make a comment and withdrew her request. If that's no longer, if you've changed your mind, Dr. Gossett, just let us know. We'll turn to Dr. Coffin in the meantime. Moderator, could you please unmute Raymond Coffin, please?
All right, this is the moderator. And Dr. Coffin, I'll be unmuting your microphone now.
Thank you very much. I would like to thank the board for the opportunity to comment on the proposed changes and also to endorse the efforts that are being made to clarify the issues in this area. I agree with Dr. Winkleman's concerns about the language that references restricting treatment to residents. I thought that I would use the time that I have to comment on some groups of patients that I personally have treated that have in the past presented issues regarding this language, or I anticipate would present complications here. I anticipate it would do so going forward. In general, the position that I take on this issue is that I would like to see California position itself well for the changes that appear to be underway nationwide to expand access to mental health treatment for all members of certainly our communities in California, but also across the country. I think the need indisputably is tremendous. So going back to the specific groups of patients that I wanted to comment on, there are three of them in addition to the students and trainees that Dr. Winkleman referred to and other groups that have been noted in other comments. These are ones I hadn't seen commented on before. First on that list is a group of injured workers. I have a significant portion of my practice made up of patients who have been injured badly in the course of performing their work duties. I'm talking here about cases, for example, of a worker who was literally buried alive under a bulldozer load of rock. And you can imagine the kinds of psychological impact in addition to the orthopedic and internal injuries that resulted in. Other patients that have suffered familiar experiences resulting in PTSD, a lot of firemen, policemen, other types of first responders who either have been exposed to catastrophic one-time incidents or cumulatively over a long career have been impacted tremendously by these experiences. A third group involves some volunteer work that I, like many other psychologists, are offering to members of the military and their families, usually beginning the service at a time when they're stationed in California, but not necessarily, I would suspect, have in every case established residence, and the future residence that they may end up establishing is unclear. With regard to the injured workers, the situation that I've faced in a number of cases is one in which, after the acute phase of treatment, these cases, which usually involve a workers' comp legal process, often drag on for some period of time. And however the legal portion of the case is resolved, they often are left in a position where they can't afford to stay in California, primarily due to housing costs. So they move out to another state. I can think of 5 different states that my patients have left for, and many times have difficulty finding clinicians in those areas who have the expertise that they need and are willing to work within the context of the workers' compensation program in California. In addition, they, and particularly the trauma cases who often have moved out of state as well, they have a real difficult time starting over, as they phrase it, going back over the details of their history with a new clinician, trying to find someone they feel safe and comfortable with.
30 seconds.
thank you, is very difficult for them and sometimes results in them dropping out of needed treatment. The alternative is that when I'm able to provide intermittent support within the legal permissions of their newly resident state, I'm often able to go directly to the issue that they need help with, provide the support that allows them to regain their balance and go on with their recovery. These are just some of the groups that I think would be potentially harmed by restrictive language. And on the clinician side, I really would prefer not to be in a position where I need to arguably determine the residency status of patients coming to me before I would feel safe treating them, particularly if their history suggests that they may have a degree of transiency or are working in jobs that move them around the country frequently, as in the case of some of the agricultural workers I've treated who have had serious injuries on the job. In short, there's a number of different subgroups of patients that I think would be potentially harmed by a disruptive change in the treatment they're receiving, the clinician that they're working with. My position is that I certainly wouldn't want to restrict them to a California psychologist, but rather that they be given the option within our regulatory framework to continue with the clinician that they've come to trust if that is consistent with the other states' laws and regulations. So thank you very much for the opportunity to comment.
Thank you so much, Dr. Coffin. So I don't see any public comment. So while we close, so for the purposes, we're going to conclude public comment. Oh, sorry, I just saw Dr. Jo Linda Crow popping at 3:07 exactly. Dr. Jo Linda Crow.
Hey, this is the moderator. Let me go ahead and unmute her microphone.
Hi, sorry. Yes, I was trying to wait till just the right moment. This is Jo Linda Crow, a CPA. I just want to make one comment about the sort of the level of confusion that exists around the issue of telehealth. And I'm sure that all the psychologists on the board certainly can appreciate that confusion because you probably hear it from your colleagues. I am pretty good at reading regulatory language. I've gotten pretty good at it, I think. I just find the language to be very confusing. And to Dr. Winkleman's point, in trying to list various situations, you know, a danger always is that once you start listing, you are definitely going to leave out something. So I absolutely concur that the term resident is problematic and would lead to a restriction for consumers to psychological services. But I would just urge the board to really consider paring this down and making it just as simple as possible. The BBS language is very clear and very easy to understand. I'm not sure that I fully understand why, why the language needs to be but as confusing as it is. So I would hope that you would just really try to boil this down so that people understand basically that if they are going to see someone via telehealth that is not in California, that they need to be sure that they are in compliance with the laws of the other state. And it's in a way it's quite simple, and then we have complicated it a lot, I think. And again, you know, my fear is that what we don't want is regulations that are going to confuse the issue more than it already is. It is going to be a huge burden for the staff to answer all the questions, because we are simply at CPA, we're not going to know the answer either. We won't know the answer. and we would never answer something about a regulatory issue. We do get calls sometimes saying to us that the board staff has referred them to CPA, but we're not really the right people to clarify for somebody whether they are violating a regulation or not. So again, if you can just really consider a way to simplify this as much as possible while still getting to the issue of providing guidance for your licensees, which is where this all started several years ago. And we all agree that that would be nice to have some guidance. I just fear that the level of complexity is going to make this very hard to sort out in the end.
Thank you, Dr. Jolene Crow. So seeing no public comment, what we're going to do is we're going to turn it back to the board for discussion with the recognition that there might be a time when we ask some questions of our public comment persons who provided thoughts. And I would like to turn to Dr. Kusuga.
Thank you, President Fu. I've been reading the changes that are proposed by the board staff, and I just wanted to echo some of the comments that others have made with regards to the term resident, and maybe either one of the board staff that has worked on this or Dr. Phillips can give me a little bit of background on why the resident term has been used. And one of the problems I see is on number 6, A subsection 6, to a client who is a resident of another jurisdiction outside of the state, who is also located in another jurisdiction outside of the state and is receiving services from a licensee within the state. It seems like they're talking about a non-resident who is receiving services from a licensee within the state. So it's kind of like that that the use of resident is I find it problematic, and I do see some of the unintended consequences of the use of resident in terms of alienating, the non-legal residents, immigrants, asylum seekers, military, and I think one of the comments that I've read talked about dislocated California residents from calamities like the fires that we've been having and, COVID. And I just wanted to kind of get some information on the history of the use of resident for the telehealth language. Thank you.
Thanks so much, Dr. Kusuga. Dr. Phillips, you have your hand raised. So Dr. Kusuga asked you a question, so I'm going to turn it over to you to respond for your
and I think actually Ms. Marks was early on involved in the drafting of this language. And perhaps she can give us some clarification as to our use of the word resident. The thing I found perplexing about this discussion is that, in particular, the California Psychological Association asked us to spell out situations. And we have, to the best of our ability, spelled out various situations. In response to some of the public comment that's recently been made, we cannot authorize you to engage in interjurisdictional practice with people who reside outside the state. That is, in part, the purpose of something like SIPACT, to create the possibility of such interjurisdictional practice when someone has no logical nexus to the state of California and you want to continue to provide service. Now, it's always possible that in looking at other states, you can see whether they have temporary practice provisions which would allow you to do services with that individual. Sometimes they're quite commodious and sometimes they're quite restrictive. Some states don't allow, to my knowledge, any type of temporary practice in their state. So it is very jurisdictionally determined. So as to the word resident, which I think is taken on a politically loaded meaning, which was not intended by way of this these regulations, Ms. Marks, could you give us a little bit of clarification relative to the discussions? I'm frankly not remembering the specifics since that language came into play relatively early on.
Thank you, Dr. Phillips. I'm a little bit of a disadvantage because my computer's decided to stop responding and I can't get to any of the materials, so I can't actually look at the ISR or the language right now, but I'll try to go from memory. And my memory is similar to yours in that when we first started discussions many years ago, there were quite a few scenarios that were brought up about, well, what happens when a student goes back home for a couple months for spring, or a couple weeks for spring break or Christmas break, or et cetera. Those, or what if somebody lives part-time in California, part-time somewhere else? And I believe we tried to address those and look at the idea of resident, which is somebody who has some connection to California, and doesn't have any significance about what somebody's legal status is. And I'm not quite sure where that comment came from, because I don't think that has anything to do with residents. It was really about how to try to guide licensees who the board licenses in order to serve the people of California, because that's our jurisdiction. So I think we looked at how do we define someone's connection to the state. So right now that's the best I can do until I can try to pull up the materials, but I'm hoping that explains why we use that definition to help guide licensees who are serving someone who has a connection to the state, because as I believe you started the conversation, we can't say go ahead and practice in all of these other jurisdictions. We don't have the authority to do that, and we issue a license here in California to allow someone to practice in California. So the term, I think we just tried to look at some terms for residency. I think we started with something that came from Franchise Tax Board or something, if memory serves, and we eventually got to where the language is now, just to put a little bit of guidelines around what the board was saying was okay in its in its determinations. We're not saying that somebody can't call across state lines. We just can't make that decision because there may be rules in another state that say you can't just call over to the people who live in our state. So I don't think that the board said you can't do it. We were just trying to outline the scenarios where we said this is okay with the state of California, with the Board of Psychology, as long as it's okay with the other jurisdiction. So does that help? I don't know if that gives sufficient background. I'm still trying to get to the materials on my computer, but hopefully it gives a little bit of context to how the conversation and the language evolved.
Yeah, thank you. I appreciate that, Ms. Marks. That does actually kind of jog my memory as well in terms of how these things developed. So we have provisions here for people that are residents of the state. We have provisions here for people who are originating from within the state, originating their telehealth contact from within the state with a California licensee. We also have a provision here for people that are located in California when they began to get their services, but are temporarily located out of state, for instance, a college student who might be going home for a summer vacation, et cetera, et cetera. I think we've covered the primary areas. Now, here's the conundrum. The conundrum is, okay, well, let's just scrap any of these descriptions of situations. There wasn't even really original intention in creating the telehealth regulations. It was to give guidance as to how to perform telehealth. I don't think that satisfies people either. So there has to be a description of the situations in which we consider a California license to authorizes people to work with people subject to laws of other jurisdictions. Beyond that, what people choose to do is going to be entirely up to them. Perhaps the guidance isn't helpful, but then I would suggest that we just take the guidance out altogether. But the guidance was requested by professional associations and now is being questioned by professional associations. So it does send a somewhat confusing message to the committee and now to the board. So I'll leave it there.
Thanks, Dr. Phillips. Are there any comments, board members, or questions to our board staff or to the folks who provided public comment? Questions, comments, all welcomed. While folks are deciding whether or not to offer comments or ask questions, I do have a question for Dr. Winkleman. So if, Madam Moderator, if you could ask Dr. Winkleman, be unmuted or unmute her.
Hi, Mr. Fu. I'm sorry, I was trying to make a comment before, but I was muted. If I could make a brief comment, and then I'll be glad to answer any questions about this.
Sure, that'll be great. And then, and as a heads up, Dr. Jo Linda Crow has raised her hand as well. So I just.
Okay. So just to clarify, I don't believe, certainly not in the last 5 years that I've been at CPA, that we asked for any interstate guidance, but we do definitely appreciate the more general guidance about how to properly conduct telehealth services. In terms of the interstate issue, I want to just clarify, we don't think that listing out specific situations makes any sense. We find it very confusing, and I don't think it's necessary because it is not a free-for-all. It would just be continuing what is currently the practice, which is that people are limited by the licensure laws and temporary practice laws from their own state where they're licensed and the other state where either they or the client might be licensed. And I think that this could be accomplished with very simple language, as I think Dr. Phillips just mentioned, which is just taking the examples and instead just simply saying in Section A that a licensee is permitted to provide psychological healthcare services via telehealth subject to the laws and regulations of the other jurisdiction, if any, where either the licensee and or the client is located. So we're giving people, that would be giving people guidance, but not adding unnecessary restrictions. And what I would say is that if there were to be any restrictions that were added on top of the currently existing licensure and temporary practice laws in California and in other states, there really should be a compelling rationale for that, especially given the current coronavirus and the incredible expansion of the use of telehealth services. So in short, I believe that we should really be looking at getting the guidance out, the general guidance, but not having limitations that are unnecessary and confusing.
I'm going to take Chair's prerogative there and ask staff. Dr. Winkleman just brought up the language that was suggested in CPA's letter with regard to making sure that we're not speaking to what is acceptable in another jurisdiction, but really focus on what we can do as a state. I'm curious to hear from staff what, in terms of the review of CPA's language that Dr. Winkleman brought up, what concerns did you have with that language? And in terms of whether or not it met the threshold for addressing some of the issues that we've articulated and talked about, not wanting to accidentally say that you can do whatever you, let me rephrase, that you can engage in this behavior absent whatever jurisdictions, other jurisdictions' rules are.
Briefly, I just want to, first of all, thank CPA for, ongoing communication regarding this package, and not just communicating, but suggesting ways in which it might be better clarified. My only concern with making it more general in Section A, similar to the language that BBS has for telehealth, is that we will continue to get telehealth calls, and Mr. Glass-Beagle can correct me if I'm wrong, but I believe telehealth is one of the common inquiries that our office gets, where we get questions about, this is my scenario, this is the provision of service that I'm providing, can I or can I not do this within the confines of the law? And I think the one benefit to laying out some scenarios is it doesn't leave room for staff to have to interpret the law and determine what kind of legal guidance to give licensees. When you have scenarios, you have concrete examples that put licensees in particular buckets where you understand which scenario an individual licensee might be calling or inquiring about. So my recommendation, just from a staff perspective and receiving many inquiries on this, is when you do have examples and scenarios, it leaves the guesswork out of interpreting the law. There's pluses and minuses to that, but I just want to lay that out for the board's consideration while you consider the amendments.
Thank you. And I have additional questions, but Dr. Jolinda Crow, I see your hand raised, so.
Oh, thank you. Yes, I wanted to just go back and comment briefly about something that Ms. Marks said, and also Dr. Phillips, because I think there might be a misunderstanding. This is a very old issue with the Board of Psychology. So I've been at CPA for 16 years now, and I've been at almost every Board of Psychology meeting in 16 years. And I think what really happened was that licensees frequently ask us at CPA and also ask the board for some kind of general guidance about telehealth, especially across state lines. Now, if you fast forward to 2020, telehealth is a much more common thing. But when this all got started, it wasn't quite as common for people to have patients who were moving back and forth and going on vacation and COVID and all of that. So what happened was people asked, where's the guidance? And there was no guidance. And so years ago, we talked at a Board of Psychology meeting about, wouldn't it be helpful for the Board of Psychology to say something about this issue? Because, again, we would get the questions at CPA, and we are not able, just like Ms. Sorek is saying, but we are in less of a position to make any comments to people that would be definitive with regard to what they can do under their psychology license, because that's not our role. We're not the regulatory agency. So we asked and talked over time about the need for some guidance. And we are not questioning the need for guidance. We are not, we're very happy that the board is trying to come to some agreement about something that both you as the board and we, frankly, can point people to and say, well, this is what the Board of Psychology says about telehealth. So I just wanted to sort of say that, because it's not that we're questioning the guidance. It's not, I don't believe it's accurate to say that we wanted it and now we don't want it. That's not really true. What has happened is that, and I definitely empathize about wanting scenarios, because everyone has their own individual scenario, which is part of the problem. So you're going to you have multiple scenarios that people come up with. My college student's going here. I'm going there for 6 months. How do I handle that? So I think our real main point is that we think it's valuable to have some guidance. It's just that we're afraid that if the guidance is too complicated, that it's going to create more questions than it answers. And by the way, I certainly never thought that the Board of Psychology was being asked or expected to comment on what other states say. So the language that you have here about as long as you're in compliance with the laws of the other jurisdiction is perfectly fine, because no one ever asked that this board try to say what another jurisdiction requires. Because I agree with what Ms. Marks said. You license California psychologists. So I think we're all kind of saying the same thing here. It's just that we're trying to get to the most elegant solution that will give some guidance. And I understand about wanting scenarios, but you're never going to cover all the scenarios. I can tell you, because we get all those questions too. You're never going to cover them all.
Thank you, Dr. Jo Linda Crow. I have an additional question for Dr. Winkleman, and I'm not seeing board members with their hands raised or with the mics. I actually do see Dr. Phillips, your hand is raised, but I'm going to ask my question first. But other board members as well, if you have questions raised, please raise your hand or unmute your microphones. Dr. Winkleman, the question about resident, I just want to revisit that issue. In your letter, you talked about DACA students, and when that example was brought up, it definitely was concerning. But I think, is there, from your perspective, is the issue of conflating between residency and citizenship, one, and two, under our existing law in California, residency doesn't have anything to do with citizenship. Residency for tax purposes, at least under the FTB, is anybody who comes to California for a purpose, which extends over a long or indefinite period of time, is considered a resident. And then thirdly, I believe if I recall correctly, AB 540 establishes that undocumented students receive in-state tuition in recognition that they are in fact residents. So I'm a bit perplexed by this question of using DACA as an example when under our existing state laws, DACA students receive the benefits of being California residents. Could you clarify why you brought up that example?
Well, I think that is one example that I was concerned about, and it may or may not be that a DACA student would qualify as a resident under the legal definition of a resident that's used or interpreted to be used for the regulations, which anyway, I certainly hope that term is going to be stricken. The fact that we're even having this discussion would certainly make me concerned that a psychologist reading these would not know who is a legal resident or not. And as Dr. Costa mentioned, that is not really the purview of a psychologist to determine who is not considered a legal resident of the state. In the definitions that were initially included in the language without the yellow and the blue, it defines the resident, let's see, as any individual who's been present in California for other than a temporary or transitory purpose or who is domiciled here, and then domiciled meaning the place where the individual voluntarily establishes themselves and their family not merely for a special or limited purpose, but with an intention of making it their true fixed permanent home and principal establishment. So it's possible that a DACA resident would be considered a resident. It depends also, I don't know, I suppose, on what the, presidential declarations are about the rights of a DACA resident. But again, I don't really feel that that should be in the psychologist's purview. And there certainly are people who are not legal residents who would not come under this definition that I have given. For example, the H-1B visa holder is clearly not somebody who is here. It's not their fixed permanent home. They have a temporary residence here. Or perhaps an undocumented person, I think they might have a hard time coming under the definition of a legal resident. So I think it just raises a lot of questions. And but furthermore, I don't see what issue it solves, given that all other states that I'm aware of and the BBS are looking at more of other ways of approaching this problem without determining the residency or nexus of the patient, but just looking at the laws that are governing the behavior of the professionals that are providing the services. And I always think back on, I broke my foot when I went to New York. I went into the emergency room, the doctor treated me. Nobody's asking me if I'm a resident or not. And I know it's different between in-person and telehealth, but there really should be a compelling reason if there's going to be any restrictions. And I just think the whole residency issue could create barriers. And I don't see a compelling reason to even go down that road. And I certainly don't think psychologists should have to determine if a patient who is requesting their services is a legal resident or not.
Thank you so much, Dr. Winkleman. That's really helpful. I know Dr. Phillips and Dr. Kasuga have their hands raised. I'm going to ask one more question of staff on this point. I muted myself. Ms. Sorek, quick question for you. First of all, the language regarding domicile has been stricken, so what's before us today is not inclusive of that definition of domicile. And secondly, from I'm hearing the staff capacity question of fielding these questions. Would staff feel comfortable opining and sharing this language be adopted today, or at least set in motion for adoption? Does staff have capacity to address this question particularly when it comes to students who may identify as DACA or?
Mr. Fu, if I may start with that question.
Please, sorry.
No, thank you. Being that I am the one that responds to the majority, if not all, telehealth questions for the board, I am torn between whether or not something simple would be helpful or whether it would just raise additional questions. One thing I have found from interacting with our population for the last 5 years, is they do seem to like very specific yeses and nos, and they want their scenario to be sort of encapsulated and something they can find that's more specific than general. And so whether or not this changes like this would increase questions or not, I truly don't have an answer on that. But I can say, just from interacting with them with telehealth questions, every email and scenario does come with a full, explanation of who, what the patient is, why they're going out of state, how long they're going to be there, where their residence is. It just gives every scenario, and so that leads me to wonder whether or not something simple would alleviate their concerns.
Mr. Glass-Steagall, let me rephrase my question. If the language here was adopted, could the board staff proactively offer guidance that with regard to residency, DACA students are considered residents and that we're not expecting psychologists to make that evaluation and determination?
I'll take this one. I think it might be helpful if staff, should the board move forward with the language as it's written, my recommendation would be that we would work with legal counsel to craft guidance in our advisory for implementation that would specify what we don't or do consider for residency, and including but not limited to kind of scenario, as Ms. Marks was identifying that residency does not pertain to citizenship status. So I think we could easily put some language together in an advisory form that we could then use as a tool to help field phone calls and inquiries from our licensees.
Thank you. Dr. Phillips, you've been waiting patiently. Apologies. Dr. Kasuga.
Hi.
Sorry, I've been talking up a storm over here.
That's what I thought. I'll let you go first, Dr. Phillips.
Okay, go ahead, Cheryl.
Go first. I know that you were somehow muted.
Okay, thank you. I appreciate it. Yeah, I think we're getting a little lost in the weeds here. I mean, if you took the example of a DACA student in California and looked at the guidance, even if they were not to be considered a resident, which I don't think is an interpretation the board would ever give to this particular situation, but even if they weren't, they would fall under other sections of subsection A. So I don't know. I think it's kind of a false issue, personally. I mean, I understand the concern, and I certainly understand the sensitivity to those people in this that find themselves in this state and is undocumented. But I don't think that is. They could also be a client who's at an originating site in the state. They could be a client who has received services in California and temporarily goes out of state. I mean, there's a variety of different ways that could be covered by this. It would not require a determination of residency, one. Two, I supervise a number of psychological interns at a major mental health center who are pretty sophisticated, and none of them have any problem determining if a client is still a resident of the state or not. If their client says, I've given up on California and I'm moving out of state, they're not a resident of the state anymore. And they know that that has certain ramifications and that they have to look at the laws of another state. Nobody's asking you to take you get voting records or to copy driver's licenses or get attestations. But if somebody lives here in the state and this is where they intend to stay, then they're a resident of the state. If they're moving to another state, don't intend to live here anymore, then they're not a resident of the state, and then we have to concern ourselves more with the laws of another jurisdiction. So certainly, maybe there's some clarification that can be done of this language. It does sound like, from staff's point of view, it is necessary for us to set out scenarios. Maybe we haven't done that as elegantly as we could have. I do recall, as early as my conversations before I got on the board with the former director of professional affairs at CPA, him wanting to find some place where he could get guidance from the board or from the legislature as to how these different situations would work. I do remember going through these scenarios at various junctures in time with the current director of professional affairs, Dr. Winkleman. I don't think it's probably sufficient to our purposes if we are going to give the staff guidance as to how to answer questions and licensees have something to hang their hat on, to not include it in the regulations. So I've kind of moved back in the other direction. I think we need to have something in the regulations that defines it. We need to figure out what that is today, folks, and so that we can move forward with a 15-day notice on this thing. Or otherwise, we're going to have the question come up again, when are your telepsychology regulations coming out? There's been an enormous amount of pressure and understandable concern about the fact that there have been no regulations from the board. I do feel like, as on behalf of my telepsychology committee members of the past, I feel like we're kind of damned if we do and damned if we don't. But I do think that pursuant to the statutory enactments, we do need to provide guidance to our licensees as best we can. I think we can cover the major scenarios. If there's a scenario that you can think of that is not covered by language, we're happy to talk about it, but it cannot be a scenario where a California licensee no longer resides in California and they're dealing with residents of another state, because that's not within our purview. So I think it'd be more productive for us to look at the language and to work our way through it.
Thank you, Dr. Phillips. Dr. Kasuga?
Thank you, President Fu. I think that with regards to telehealth guidelines, and I remember last board meeting, I was one of I voiced out the need for increased direction and guidance on telehealth. So I think that there's two things here that we're providing guidelines on. One is on how to conduct telehealth, and then the second one, which is more contentious, is the restrictions on telehealth, and that's where the interjurisdictional issues are being discussed. And I think that's where there's a lot of disagreements whether to be more specific or to be more broad. So personally, I think that the parts of the telehealth guidelines that is more important for me is the how to conduct telehealth, because it's really providing guidelines on everybody on how standard of practice for telehealth. With regards to restrictions on telehealth, I'm not sure there's going to be consensus to be had today. For me, the original Section A without the specific examples is sufficient to make sure that licensee is just practicing within what is allowed in general in terms of restrictions on telehealth. But I think those are two different things. I think that the telehealth guidelines is providing ample guidance on how to conduct telehealth, but I'm not sure it's what people are asking on the on clarifications on restrictions. And and I understand that, probably Mr. Glass-Steagall has experienced a lot of questions with regards to practitioners asking whether can they do this, can they do that, based on interjurisdictional, movements of their clients and themselves. I'm just trying to kind of find a solution so we can move forward with the telehealth guidelines and not be bogged down by the kind of disagreements on the restriction issue. Because what Dr. Phillips said, there's really not much we can do about interjurisdictional issues when it comes to providing services. So that's kind of my thoughts on it.
Thank you, Dr. Kasuga. Ms. Sorick?
I just wanted to add some context to the history of this change, especially for new board members. This package, like the continuing professional development package, has been the subject of 3 sunset reviews, and timeline-wise, sunset reviews happen about every 4 years. So this is something that has been a work in progress for some time, and we have been asked for guidance from our licensees on the provision of telehealth, and we've gone back and forth on this issue. I don't mean to push, but I do want to let the members of the board know that if there is a possibility that we can, that the board members can come to an agreement on some amended language, either providing scenarios or not providing scenarios. We haven't heard from any interested party who the scenarios are helpful for, but if there are any organizations or individuals that support the scenarios, I'd be interested to see if there is anyone in support of that. If not, perhaps the board members would consider amending A to be more general and just deferring to the laws of the other state. I would just say that with the caveat that, again, when we get inquiries, which I know we will, on does my scenario fall into category A, staff is going to have to interpret the law and decipher whether or not their scenario falls under the existing regulatory framework. So I just want to put that out there, a little historical context, a little push to move forward in progressing on this, and the pros and cons on amending the scenarios or not.
I'd be happy to do a motion if that's necessary for this moment.
Dr. Kasuga, let's hear your motion.
So I move to adopt the changes to the original proposed language shown on the blue text without the circumstances on A.
So Dr. Kasuga has made a motion that I'm going to rephrase your motion, Dr. Kasuga, a little bit based on the language we have before us in the memo, but you can tell me to scrap it. So what you're asking is for a motion that for the board to delegate to the executive officer authority to adopt the modified text in the absence of any negative comments and continue with the process to finalize the regulatory package, including making any non-substantive changes. Is that accurate?
That is
with the adoption of the language you've articulated with regard to attachment G with the modified text.
Yes.
Thank you, Dr. Kasuga. Is there a second to the motion?
Could you repeat the motion again? I'm losing the plot here.
No worries. I'm essentially reading off on the second page of the memo, what action item, and the motion is that the board delegates to the executive officer authority to adopt modified text in the absence of any negative comment and continue with the process to finalize the regulatory package, including making any non-substantive changes using the language in attachment G.
And modified, including scrapping out the specific examples.
Sorry.
A, 1 to 6.
Mr. Fu, this is Noreen Marks. I just want to get some clarification around that. I think what I heard you say was the motion was to approve the modified text, but I think I heard Dr. Kasuga say approve the modified text except for in subsection A.
Yes, I misheard. I didn't hear that portion, so that was my apology, Dr. Kasuga.
So I'm not entirely sure then how subsection A would read if she's saying let's go back to the original text, which I don't think is what Dr. Kasuga is saying, but she can speak for herself. I just want to get clarification around the motion. And then also make sure we get clarification around the board's acceptance or rejection of the comments as set out in I think it's attachment D.
Dr. Phillips, you're not here right now, so I can hear you typing.
Oh, sorry. Yeah, I just wanted to say one thing, and that is that is an easy solution, I think, to the immediate situation, except neither CPA nor our staff are going to have a regulatory basis for responding to questions regarding is this okay, is this not okay in terms of my license in California. So I don't even know what the purpose of subsection A is really. That's what we're going to do because it doesn't give guidance to anybody about anything.
Dr. Kasuga, could you clarify? My apologies. I misheard and misunderstood and totally messed that one up. So I apologize. Could you, what language are you looking to adopt and what are you striking out?
Yeah, I was responding to what Ms. Sorick said earlier with regards, maybe we can talk about adapting the language and given that there seems to be nobody who's saying that the specific examples is helping them, I was proposing to adapt the language and exclude those specific examples on A, subsection 1 to 6. So we can have more of a focus on the telehealth guidelines that is most beneficial for everybody. But I understand that, like what Dr. Phillips is saying, that he's questioning that might not be enough guidance if absent those examples.
Could I ask a question? This is Dr. Harbsheets. You know, a number of the comments address the concern about interns, trainees, people who are not yet licensed. I haven't heard any discussion specifically about that. We've talked mostly about what does it mean to be a resident, how does that work, but have I missed something? I mean, I've been here, but I think that's really important for us to address too.
That's addressed in the blue language in B. We expanded the definition of a licensee to include a trainee or other supervised individual. So that was to address that public comment.
Oh, I see it. I see it. Yes, I see that. Thank you. So that's
Sure.
what we haven't discussed it, but good. Okay, thank you.
Mm-hmm.
So Dr. Kasuga has a motion on the table that would, just for clarity, to make sure because I messed this up the first go around. Essentially, you're proposing, Dr. Kasuga, to strike basically 1 to 6. So So you're saying the language you would want is a licensee is permitted to provide psychological health services via telehealth, subject to the laws and regulations of the other state where either the licensee and or the client is located, period. Correct?
Correct.
Okay. Do we have a second for that motion?
I'll second it. This is Dr. Harbsheet.
Okay. So I'm going to, is there board discussion with regards, procedurally speaking, what we're going to do, since we have a motion on the table with a second, we're going to have a board discussion about it, go to public comment for the motion, and then take a vote on the motion if there is an additional board discussion. So is there additional board discussion on the motion that Dr. Kusuga has proposed? All right, so Madam Moderator, could you open up the public comment section on this motion? And so I just want to be very clear that the public comments should be relevant to the motion before us. So, yes.
All right, this is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on the motion, please click on the icon of the question mark within a square located at the bottom right-hand corner of the WebEx screen. I'll go ahead and pause a moment to allow members of the public time. Oh, and we do have one individual who has requested public comment. Elizabeth Winkleman, I believe your microphone, you can still unmute it, so you should be able to unmute yourself.
Yes, thank you very much, Dr. Winkleman again from CPA. I just wanted to thank you, Dr. Kusuga. I think this motion would be very helpful. I do think it is providing advice to psychologists, and that is saying, referring them to the laws and regulations of the other jurisdiction if another jurisdiction is involved, without getting into any unnecessary additional restrictions or any discussion of residency and so forth. So I think it would be great. I think it will reduce the number of questions that the staff will get. And I can say that because I'm the person who at CPA gets the questions that Mr. Glass-Steagall gets for the board. And there are a lot of them where we simply can't answer because we need to refer people to the other state. The one suggestion I would suggest you consider is changing the word jurisdiction. The word state, where it says subject to the laws and regulations of the other jurisdiction, instead of state, that you might consider that as a friendly amendment or whatever the technical term is, because as I'm sure Mr. Glass-Steagall knows, you're also going to be getting questions about international. So thanks very much.
All right, this is the moderator, and it looks like there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Thanks so much.
Okay, the Q&A panel is now closed.
So I have a, Noreen, sorry, Ms. Marks, your microphone is unmuted, so I assume you have something to say.
I just wanted to check in on a sort of on a practical level as someone who has also been asked the questions by staff of whether or not this will assist staff in answering some of those questions, because as I understood it, when the staff answered a question about calling into providing services to clients in another state, and the answer from our board was at that other state, I understood that many of the licensees then responded, they told me to ask you. So I just want to make sure we're not setting up a situation where it becomes like a round of, I don't know, what do you think? I don't know, what do you think? To put it in kind of colloquial terms, and make sure that the board staff who does answer these questions will have the guidance that they need.
Thanks, Ms. Marks. That's actually my concern with what's proposed by Dr. Kusuga. I'm sorry. I just also want to make sure, Ms. Riscate, I think I just saw your mic go unmuted. Did you? want to say something? Okay, maybe I misunderstood. That's my question to staff. As proposed with the amended language with the motion before us, how do you go about, what are the next steps? What does this mean?
So the next step wise, and Mr. Jackson, correct me if I'm wrong, but the board will need to consider the public comments that were provided and respond to those public comments by either rejecting the comments and saying why, or addressing them in the language which staff has already started to do with the blue language. A possibility would be, and I hate to push another thing off until tomorrow, but one possibility would be to continue this discussion tomorrow, have the board members consider the motion and the language and the comments, and that's a possibility. Mr. Jackson, is there any other guidance you would like to provide on process?
Hi. The way I'm looking at this is having worked to go through all of the written comments, most of these comments are already contained in the written comments, and so I wouldn't see it as a heavy lift to be able to go through today's oral comments, put them into the same buckets as the written comments before, and discussing them tomorrow. I think you had a good idea. So,
thank you, Mr. Jackson and Ms. Sorick. Dr. Phillips?
I would just, since we're going to be continuing this, I would just ask the board members to consider what the purpose of passing a regulation is that gives no guidance, nor does it help staff to answer questions. We may have done it inartfully. We might want to revise the language during the context of our discussions tomorrow. But I think at this point, we're just kind of abdicating our responsibility. And it concerns me that we're doing so. If that's the will of the board, that's the will of the board. But I think we're basically passing a regulation that gives some guidance as to standards for practicing telehealth, but doesn't answer the primary questions that licensees are asking themselves. So I think that's a real dilemma.
Thank you, Dr. Phillips. Dr. Tate?
I've been quiet for a while because I agree with Dr. Phillips. I see a lot of work has gone into this, but I don't see passing this regulation as fruitful for anyone at this point. So maybe tabling until tomorrow until we can think about it. It feels like a lot more work needs to be done, or not done for that matter, around language. There were so many letters with concerns. I don't have the exact solution, but I think we're really deep in the weeds, as Dr. Phillips said. So those are my thoughts.
Thank you, Dr. Tate. Any additional comments from the board? Just want to make sure Harv Sheets, Ms. Cervantes, Ms. Nystrom, or Ms. Riscate, Dr. Rogers. Dr. Rogers, I see you're unmuted.
Yes, I just have a couple of comments and my thoughts about being a grammar enthusiast. I just wanted to throw this out for consideration. So the way I'm understanding it is that we're looking for language that's not confusing to licensees, but provides enough structure for staff to answer questions if and when licensees or trainees call about providing telehealth services. So I was wondering if it might be helpful if we're looking at Section A, where it says a licensee is permitted to provide psychological health services via telehealth, strike out the part that's in yellow, subject to the laws and regulations of the other jurisdiction. I think Dr. Winkleman recommended that word be placed there. And then continue on. And when we get to the section that says other jurisdiction where either the licensee and or the client is located, so the next word is under, could we insert but not limited to? So that way 1 through 6 get to remain in order for staff to be able to answer the questions, but it's not so constricted that it creates more confusion for the licensee.
Thoughts about Dr. Rogers' suggestions?
I like it. And then I think maybe we can refine that language down a little bit.
Mm-hmm.
And go through each one of those items to see what we can do to tighten that language up, and then move on. But at least it'll give some guidance. We can cover some of the scenarios in which it would be possible. I think it covers the major scenarios that we were able to anticipate. But as people have said, there could be unanticipated scenarios that I guess we'll have to take a look at.
Thank you, Dr. Rogers and Dr. Phillips, on that.
Do you want me to withdraw my motion, and do you want to propose a motion, Dr. Rogers?
No, so I was going to say, Dr. Kasuga, instead of voting on your motion, if you could withdraw your motion, and we're going to just move this to the next day, because my understanding from Ms. Sorick and Mr. Jackson is that it might be helpful for us to include what Dr. Rogers has just offered and actually provide it in some written format for us to look at. So if you're amenable, you can withdraw your motion, or we can vote on your motion and see what happens.
I'm happy to withdraw my motion. I just wanted to also urge the board members to consider, as part of the deliberation for the telehealth language, that how I see consumer protection is not just preventing client harm, but also making sure that there's access to services, because that is also part of our mandate to make sure that we're not unduly restricting or there are no inadvertent effects to that account with the language that we are putting forth. So I just wanted to kind of like have that in the back of our minds as we try to craft the perfect language to make sure that we're able to provide guidance for people that are needing it with regards to telehealth, and making sure that no one is inadvertently restricted from practicing psychology that is needed within our consumers.
Thank you, Dr. Kusiga. I appreciate you withdrawing that motion so that we have further time to deliberate. I was just going to add on my end that I really shared Dr. Phillips, Dr. Tate's concerns about the language, and I'm excited to look to tomorrow with the inclusion of what Dr. Rogers has suggested. I think, Mr. Glass-Steagall, it might be helpful to have Dr. Rogers' comments, like if you can produce it and share it with us so we can see what it looks like with the edits she's made, I think would be really helpful. And we will hold this item for further discussion tomorrow.
Yep, Clay and I will work on it tonight.
Thank you. And Dr. Kasuga, I see your hand up. Did you have additional items to add?
I don't. Sorry.
All right. Thank you. Okay. So what we're going to do now is we're going to take a break because.
I have my hand up.
Yeah, I have mine up too. Is there opportunity for other additional public comment, or are you closing this out?
I would ask that because we're continuing this conversation tomorrow, and we did open public comment twice for this item, that you hold your comments for tomorrow, so that it's very fresh when we discuss it again tomorrow. If that's acceptable, if that's acceptable to you, you're more than welcome to say something now, but I would appreciate it if we just held it for tomorrow.
Mr. Fu, I have one thing that I do think it's important to consider before tomorrow, which is it's still unclear to me what is being restricted. So I think that if there is going to be some kind of a restriction in listing, that it's important to understand that. And I also would like to say that although several people have mentioned licensees want guidance, I'm quite sure, and if we look at the written comments, they don't want restrictions, and they don't want to be limited in the kind of care that they can provide that's clinically indicated and that's otherwise permitted under various states' licensure and temporary practice laws. So please, for tomorrow, if we can get a clarification on what is being prohibited and why, and I hope that the board will consider either not using the examples or using examples, and also if they do the examples, to consider striking the word resident and not just closing off these other aspects of the discussion.
Thank you, and I believe those comments were earlier, so we will have those comments repeated.
I just made very quickly, and because it might inform the board's thinking about this tonight.
Or repeating the comments?
Nope. Yes, new. I want to go back to the idea that Dr. Tate raised and that Dr. Phillips raised. I do think it's very important for the board, and Ms. Sorick said this too, very important for the board to issue some guidance. And to put it on a very simple level, the reason it's important is not that you're trying to tell them what they can do vis-a-vis another jurisdiction. What a psychologist wants to know, and the best simple example is a college student. I've been treating a college student. They're going home for the summer. Can I continue to see that student via telehealth over the summer? What they want to know and why they're asking you is that they want to know, is it okay with you? And then, in other words, if it's okay with the state where the student has gone for the summer, am I going to get in trouble with my board if I do this? So that's why the guidance is important. And as Dr. Phillips mentioned earlier, to say, and I think this was the original intention, as I understand it, was to say, it's okay with us, but you need to be sure that it's okay in the other jurisdiction. So the idea of providing guidance, I do think, is very important for this board to consider. So I really appreciate your taking such care with this.
Thank you for reiterating your earlier point. So this item is held for later, for tomorrow. I just want to make clear that item 16 is informational only, so we will hold that item as well, since there are no action items in item number 16, and we will bring that up tomorrow, time permitting. So what the board is going to do is we're going to take a 10-minute break, and then we're going to go into closed session to meet with regard to Government Code Section 11-126C3 to discuss disciplinary matters, including proposed decisions, stipulations, petitions for reinstatement, or modification of penalty, petitions for reconsideration and remand. Board members and board staff who are supporting us during the closed session stay on the WebEx because we're not going into the, we're using the WebEx platform for a closed session now. So thank you all. And then I should also mention that, as I said earlier today, the board will also be meeting in closed session tomorrow for those same items from 9 to 10, and we will gavel in at 10 and then return to closed session for our EO evaluation. So if board members can return back to WebEx by 4:30, in the meantime, if our folks at Solid who've been helping out all day, if you can appropriately secure the room for closed session, that would be appreciated. Thank you.
All right, this is the moderator. If I could also ask that board staff don't actually log off the meeting, considering I just locked the meeting, so if you try to join back in, you won't be able to. I'll go ahead and remove any public who are in the call and then get everything set up for closed session.